way. Complainant stated that she was unable to tell if he was a wreck, but she was able to clearly see his.
Do you have any questions, sir?
We got a sovereign citizen in court today, and the charges? Indecent exposure, touching himself in public, while staring down a woman. Yeah, it's exactly as bad as it sounds. And just like you saw, this guy completely snaps in the courtroom. No filter, no strategy, no self-awareness. Just pure uncut chaos. But honestly, the person I feel most sorry for here isn't even the judge. It's his lawyer. Just look at her face. You can literally see the regret washing over her in real time. Sitting there, stiff, uncomfortable, quietly questioning every life choice that led her to this exact moment. Years of law school, bar exams, late nights studying case law, all to end up sitting next to that. Meanwhile, Judge Flair is already done. The courtroom is unraveling. And this whole hearing is about to go completely off the rails at full speed. Buckle up, because this one gets wild. Roller coaster, let's dive in. And drop your thoughts in the comments as we go.
What was the last name again?
Lane, Brandon Lane. Yeah.
So, Mr. Lane, you were charged with. All right, you were charged with indecent exposure. You wanted to do the PC on indecent?
Yes, Your Honor.
You're charged with indecent exposure. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
May 26, 2024, officers were dispatched to a defendant touching his private area at the Metro-owned downtown transit center located on 1900 Main Street, Harris County, Texas. The officer was advised by Metro Dispatch that the complainant called and stated that the defendant was exposing himself to her. Complainant told officers that the defendant was a black male in a blue hoodie and boarded a Metro bus, and then ultimately pointed the bus that he had boarded. Matching the description, and complainant witness confirmed that that was the same person. Complainant stated that the defendant followed her from across the street, pulled out his penis, and started exposing it to her and looking at her. She further stated that the defendant began stroking his penis back and forth with his hands, looking at her without speaking, approximately 5 to 10 feet away. The complainant stated that she was unable to tell if he was a wreck, but she was able to clearly see his penis as he was stroking.
Your Honor, after speaking with my client, the officers approached 2 males. I have to wait on body cam to see what the other male looked like, but my client's saying that wasn't him. He just.
I mean, I don't know. I think that there's probable cause to go forward now. Mr. Lane. Mr. Lane, we will get the body cam to ensure and see if that is in fact you, because we don't know. All we know is that we have someone that has identified you. I will try to have them get the do you have it now? What evidence do you have now?
This is a brand new case, Your Honor. This is the 26th, so I don't know. There's nothing in yet, so I literally just wrote this up before I came to court.
Okay, I will, Mr. Lane, I will try to have them get the information and the body cams as quick as possible so we can verify that it is you. I would say let's try hopefully a week. The problem is that I can't give you a PR bond because you continue to take off on us. I had your evading arrest at 7503 because we can't get you here. So, okay. Do you have any questions, sir? Hey, hit the button, please.
Yes. candidates. Now you start with New York.
Not the best time for me.
I don't know if it was necessarily him.
All right, same thing happened down there with me.
That was, no,
Hey, Ms. Hayes, can we have him evaluated, please?
On his previous case, Your Honor, his first case in your court, he was already set for a mental health evaluation, but he absconded. He's homeless.
He's,
So,
the look that he was giving us, did you see me eyeing you to?
yes, I moved over, yes.
oh, you see where I came from? You see-
Oh, yeah.
He's pretty coherent when I'm speaking with him, but I've seen the episode
I
coming
just,
about. So he's gonna be in custody. Hopefully we can schedule the evaluation. I'll speak to the CLO and go from there.
for sure.
Thank you.
Hunter,
That was one of the wildest courtroom meltdowns I have ever seen. Flush-faced, this man walked and presumed innocent, and somehow managed a self-sentence in real time. No prosecutor needed. No closing arguments. Just pure, unfiltered self-destruction on full display. Slamming his head on the table like he just got a notification that his free trial of sanity had officially expired. Skull and look. If the indecent exposure charge wasn't solid before, it is now. Not exposure of his body this time, but full public exposure of the most dangerous thing he's got, zero self-control. But real talk, massive props to the attorney, because the way she was slowly, smoothly backing away the moment he started transforming, she already knew. That quiet drift backwards was the body language of a woman who was mentally clocked out, packed her desk, and is already composing an email. I regret to inform you that I can no longer represent you. Faced with tears of joy after that mean mug he threw at the judge, she's not just done, she's gone.
If you are in the box, do not talk to your client while we're on the record. How do you know we're on the record? Because I call the style of the case. I keep saying that. And what I keep saying is, I don't understand when we're not on the record, everybody just sits there and don't talk to anybody. And the minute we get on the record, that's when everybody wants to have a conversation. I have patience in my pocket, but slowly but surely that patience is going to wear out. Everyone who's on the trial docket, if you are on the trial docket, you need to have the court coordinator or the clerk pull your file so I can let you know when you can be back here for trial, because we're not going to do this thing where everybody is rushing up here at 12 o'clock when we're actually taking our lunch at 12, because the prosecutors need a break at 12. The staff needs a break at 12. The court reporter who's been taking down everything that everyone's been saying needs their break. The probation officer needs their break. And do not approach the coordinator or the clerk when we're on the record. Again, how do you know we're on the record? Because I call the style of the case. Now, I hope everybody understands. And now that I've said this, you know what's going to end up happening? I'm not going to hear any chatter, and we're not even on the record. The end.
Okay, real talk. Seeing Judge Boyd lose her cool like that was a first for me. Genuinely didn't see it coming. Grinning face with sweat, but honestly, I don't blame her one bit. Think about it. You're a judge. You got a full docket, a packed courtroom, and all you want is 5 minutes of basic order. Maybe make it to lunch while the food's still warm. And instead, every lawyer in the room is simultaneously rushing the bench like it's Black Friday at Walmart. Shopping cart, the chaos. The noise, the complete disregard for process. Yeah, she snapped, and she had every right to. This isn't even just about patience. Under Rule 3.5 of the American Bar Association's model rules, attorneys are prohibited from disrupting court proceedings. So Judge Boyd wasn't just frustrated. She was absolutely legally 100% justified in shutting it down hard and fast.